Paul J. Beard II is on the line with us. He's the principal attorney with the property rights group Pacific Legal Foundation. Pacificlegal.org is the website. Paul, welcome to the program.
Hey, thanks for having me, Tom.
My pleasure. Your organization is generally regarded as a conservative, advocacy group or law group, or what? How would you describe it?
No, we're a legal group, and so we represent property owners and other individuals for free in the courts to protect their rights, including their property rights.
So here's this billionaire, Vinod Khosla. Am I saying that right?
Right, Khosla.
Khosla, almost like coleslaw. That he bought this piece of beachfront property, some 40 acres of beachfront property, and it used to have a road through the middle of it so people could get to the public beach on the far side. And given that, the beaches all along California are considered public property, or at least the vast majority of them, there's some, I suppose, that were grandfathered and aren't. But he closed that road, thus denying an easement that was not a deeded easement. And you're arguing that he should have the right to do that, to keep people off his property so that they can't get to the beach. Do I have that right?
You got it. A couple of corrections. It's entirely private. Even the beach is private, and the road, of course, that leads to the beach is private. A Superior Court recently found that it was entirely private. So the question is, can a vocal minority of surfers, activists, public access types, can they force a private landowner to open up his land in order to get to the beach, which in this case, again, is private? That's the central question in this case, and that's what the battle really is all about.
Is the beach private at the high tide mark or at the low tide mark?
This is a unique case in which, as you mentioned a little bit ago, that some properties are grandfathered in. This one was kind of grandfathered in from the mid-19th century through the Treaty of Guadalupe Hidalgo. It was originally part of a Mexican land grant that was then ceded to the United States with the recognition that, Mexican landowners would have their property rights protected without any recognition of a public trust or public easement across the beach area. And so this is one of those unique properties in California that actually doesn't have a public trust over the beach. It's entirely private. And so the only question is, can the public nevertheless access that beach as a matter of right?
Well, no, my question was, and I've seen this debated with a level of minutia that makes me cringe. If you're walking in your waist in water off that beach, you're in a public waterway, right?
I don't know exactly how far out you'd have to go before it becomes.
Because that was my question. I mean, I've seen. I mean, this is oceanfront property, so there could be, depending on how gradual the slope is going out to the ocean, there could be between 5 and 150 feet of land that appears during low tide and vanishes during high tide. And so my question is, during low tide, is that land considered public land? Because if it is, then I think a strong case can be made for there being a de facto, if not a de jure, easement there. Or public.
I don't know the answer to that, and that's not really in dispute in this case. The question really involves the sandy beach area above the mean high tide line landward,
right,
and the private road that leads to that sandy beach area where people recreate. There's no question that people can navigate and even wade in the ocean area that fronts the property.
Right.
But they can't get there without his permission via his property. That's the only real question in the case.
Right. So what is the principle? What are you defending here in defending this billionaire? What is the principle you're defending?
We're not actually so much interested in this Mexican land grant issue. It's sort of taken for granted that the beach area is private and the private road is private. What's occurring here, though, is that activists are trying to use provisions of the California Constitution and other doctrines to say, well, regardless of the fact that this is all private, we think the public has a constitutional fundamental right to cross his land and recreate at the sandy beach area, even though they're private under the law.
Right.
They feel that the Constitution or some implied easement doctrine allows them to use the land nevertheless. And that's really what Pacific Legal Foundation, my organization, is fighting against. We don't represent the landowner in this case, but we're watching it very closely, and we're interested in ensuring that these doctrines don't override private property rights.
Why?
Well, because we believe in the fundamentality of private property rights. We don't believe that just because the public needs access, and
that they should have it.
It's a small minority, that they need access, that therefore they should get it without paying just compensation. Now, the state does have the power to condemn private property for public use if they pay compensation, but that's not what this case is about. The plaintiffs in this case, there are a couple of cases pending, and others are trying to use the legislature, the courts, the administrative agencies who control land use to force the landowner to just give away his rights without payment of compensation. And that's what we object to.
So you're making a Fifth Amendment argument that this is a taking?
In a sense, well...
And that there should be compensation for it?
The other side is arguing we have a right to public access via these various doctrines, and we say there is no such right. The public can't supplant private property rights in that way.
Oh, the public does that all the time, Paul. Yeah, the public takes public property rights to build roads, to build bridges, to build highways, to build hospitals, schools. I mean, it's called eminent domain. Yeah, but you're right. There does have to be compensation.
Right, and that's the key here. Does the state, if this private property is so precious that the public needs it to access Martin's Beach, then they can lobby their legislators to conduct eminent domain proceedings in a rational and fair way and provide compensation to the landowner for condemning the private road in the beach area. Yeah. That has not been done. They've been using other means of getting around the compensation requirement through the media, through coercion in the media or in the courts or the legislature to try to get this landowner just to give away his rights, in essence.
Well, the flip side of that is that this is at what point do we say this is not part of the commons? I mean, the by and large, the California Constitution and California law recognizes beaches as part of the commons. You've got multimillionaire Hollywood stars in Malibu who are stuck with beachfront where anybody can walk on it. I mean, it's just that's right. Welcome to the world. And as you point out, this land apparently came through something that preceded the Mexican American War, President Polk's War or something, whatever, and it's got this weird deed associated with it that apparently is in violation of the Constitution. What's wrong with saying the public has the right to use beaches?
There's nothing wrong with that principle so long as the public pays for it. Now, what you're talking about is a public trust across the beaches in California up to the mean high tide line, and that's true that it exists for most property. But you've got a deed here that was established via federal patent proceedings, the United States Supreme Court. There was even a case that said, yes, this passed through legally through the Mexican land grant process, and we recognize the rights of these owners.
Right, but we're not Mexico.
Right, but there was a treaty that concluded the Mexican-U.S. War in the 1800s that required the United States to respect the pre-existing property rights of Mexicans.
Well, there were, there are a lot of treaties from the 1840s and 1850s that mostly with Native American tribes that we have seen fit to just completely ignore.
Sure, and that might be the case with the Indian treaties. I don't know enough about the Indian treaty situation, but we do know that here there's no dispute, not even among...
Well, this isn't an Indian. This is a billionaire, so he can fight it. He can fight it. Okay, Paul, thanks for the... It's an interesting story. Paul Beard with the Pacific Legal Foundation, pacificlegal.org. Thanks, Paul, for dropping by.